Fraud Act 2006 put up a competent fight against fraudsters who use technology for their own gain. And to what extent must it evolve to eradicate the blight of fraud in Britain today? The Fraud Act 2006 drastically changes the landscape of criminal law, and practitioners have really embraced the well-defined offence of fraud. Now, the driver behind the Act is that it sets out to capture dishonest activity by fraudsters who dwell in cyberspace and who manipulate, if you like, our ever-increasing reliance on automated methods of transacting. This programme looks at the key provisions of the Fraud Act 2006. Specifically, we focus on the general offence of fraud under the three limbs of false representation, failure to disclose information, and abuse of position. We also consider new offences of obtaining services dishonestly, possessing, making and supplying articles for use in frauds, and fraudulent trading applicable to non-corporate traders. The changes should help to close a number of loopholes that used to be open to abuse. The new offences really have moved with the times and cover a broad spectrum of activities, from false representation, whether to machine or man, through to abuse of position. Now, the common denominator is that the fraudster needs to act dishonestly with the intention to gain. And the penalty for a guilty verdict is up to 10 years imprisonment or a hefty fine. Deception and the impact on a victim's mind have always been the key to a conviction of fraud. Significantly, the Act dilutes this concept, moving instead towards an examination of the dishonest intention of the fraudster.
The old law on fraud was set out in the 1968 Theft Act, and the problem was that it concentrated far too much on the effect of the fraud on the mind of the victim, rather than concentrating on the intention of the perpetrator. Secondly, it required proof of obtaining property through the deception that was perpetrated, and this led to all sorts of difficulties, especially where you had transfers of sums of money in one bank account to another, and it was found to be far too inflexible.
The old law on fraud was made up of two main areas. In the first place, there was the statutory law given by the Theft Acts. In the second place, there was conspiracy to defraud, the old common law offence. The Theft Acts suffered from a problem of being very narrowly defined and therefore open to technical assaults. The conspiracy to defraud, on the other hand, was thought to be far too widely defined and too unclear in its terms.
Although fraud has always existed as a concept, practitioners have never had a statutory definition of fraud or any common law structure to guide them.
It was a hodgepodge of various offences, generally requiring dishonesty or intention to defraud or fraudulent approach in order to make a person guilty. The advantage of the new Act is to try and bring together a number of offences under the title of fraud, which can then be prosecuted as fraud.
The Law Commission recommended that the common law offence of conspiracy to defraud be abolished under the new Act, since it was decreed as too vague and led to anomalies in practice. Some argue that the golden opportunity to put it right under the Fraud Act has been missed.
Conspiracy to defraud ought, in my view, to have been abolished. It was the recommendation of the Law Commission that it should be. It is a very vague offence, and therefore depends very much on the view taken by a jury as to what is dishonest. In addition to that, it gives rise to certain anomalies. The most obvious example of this is that a person may be permitted on their own to do an act which, if they agree to do with another party, becomes a criminal offence, and that is obviously undesirable.
Further discussion on the anomalies caused by retaining conspiracy to defraud can be found in the accompanying LNTV Times. The Fraud Act 2006 received royal assent on the 8th of November 2006 and is expected to come into force in spring 2007. The Act establishes 3 heads of committing the general offence of fraud. The notable core of the Act is that it looks at dishonesty by the fraudster, as opposed to whether a victim has been deceived.
The Act creates one offence of fraud which can be committed in 3 different ways. It can be an offence committed by representation, by failure to disclose, or by an abuse of position.
Section 2 of the Act deals with instances where a person commits fraud by making a false representation dishonestly and intends to make a gain.
First of all, there must be a representation. Secondly, it must be false. Thirdly, it must be made dishonestly. And fourthly, there must be an intention on the part of the person making it to gain from himself or another, or to cause loss to another, or indeed expose that other person to the risk of loss.
The word representation is defined broadly and is intended to include anything, be it by conduct, or be it an express representation, or indeed where someone sends out, for instance, a phishing email, they're thereby representing that it's a genuine email coming from the bank, and they're doing so dishonestly and with intent for a gain for themselves.
One of the problems with the deception offences under the old law was that the deception had to play upon the mind of the victim. But this doesn't cover instances where the fraudsters used machines, for example, to skim credit card information at a cash point or to commit chip and pin fraud. The new Act bridges this gap.
One of the difficulties with the existing law was that it was failing to keep up with the pace of change in technology. For instance, when someone buys a contract of insurance over the internet, the chances are that there's no human mind at the other end involved in the transaction at all. Therefore, if someone uses a false credit card to do so, they're not in fact deceiving anyone, simply a machine who can't be deceived. The new law brings the focus onto the conduct and the state of mind of the offender, rather than requiring a victim to be deceived, and thereby the problem is solved because all that's required is a false representation, and that would be there.
Section specifically deals under subsection 5 of section 2 with the situation where a representation is made effectively to a machine that has no human mind to be operated on, and under that provision it is now possible for someone to be charged with an offence under section 2 if they take a stolen card to a cash machine and seek to obtain cash from the machine.
The obvious way to most people would be the use of the chip and pin number. Once, of course, you enter your PIN number into the machine, you are, in fact, under Section 2, subsection 5, making a representation to that machine. And if it's false, of course, then you may be putting yourself at risk of prosecution. Also, of course, these days of computers and modern technology, it's highly likely, and no doubt the Act was designed to cover this situation, that representations made and put into the web, as it were, are likely to find themselves as subject to prosecution as well.
The use of modern technology, and in particular internet commerce, means that very often people are making representations to machines. When these are fraudulent, they wouldn't have been caught by the old Act, but they are caught by the new law.
Section 2, subsection 5 attempts to take into consideration modern technology. Whether it succeeds in due course, we'll have to wait to see. What it provides is this, that in fact, if information is input into a system or device which is designed to receive, convey or respond to the input of that information, that can itself amount to a representation. And therefore, providing it is false and the other elements of mens rea are present, then it is possible, as it were, to make a representation to a machine.
It's now critical to determine what the intention of the fraudster is, not just what impact his actions have on the victim.
Under the new law, it doesn't matter whether or not the representation has any effect upon the mind of the victim. The focus of the offence has moved from under the old law to focusing upon a person being deceived, i.e. the victim's mind, and it shifted to the mind of the person making the statement, the offender, whether or not they were A, dishonest, and B, had an intent to defraud.
The long arm of the Fraud Act 2006, in the form of Section 3, also reaches those fraudsters who are under a legal duty and who dishonestly fail to disclose information for gain.
Failing to disclose under Section 3 requires, first of all, that the person who is to be the defendant or the suspect is under a legal duty to disclose. Secondly, of course, that he fails to disclose. Thirdly, that he does so dishonestly. And finally, that he does so with the intent to gain or to cause loss, as I mentioned.
Section 3 of the Act is there to deal with a very narrow group of frauds, but it's there where someone's under a legal duty to disclose something and doesn't disclose it as a means of perpetrating their fraud. An example of someone under a legal duty to disclose would be a company issuing a prospectus under the Companies Act. FSMA, the Financial Services and Markets Act, makes particular requirements of what must be put into the prospectus. If someone fails to disclose something that they must disclose, and they do so in order to perpetrate a fraud, they'll be caught by Section 3 of the Act.
A legal duty will arise, obviously, in a contractual situation, and it may well indeed arise before a contract is entered into. There are statutory requirements which will impose legal duties on people. It's also a moot point as to whether or not the law of tort will impose duties upon persons. For example, if there is a duty owed by one person to another, if resulting from that there's a failure to disclose, that may well make that person liable under Section 3.
The final of the three heads is abuse of position under Section 4.
Fraud by abuse of position is there to catch people really in fiduciary relationships who use that position in order to commit fraud. An example would be a solicitor-to-client relationship or an employee-employer relationship. The intention is to be broader than fiduciary relationships, but essentially it's fiduciary relationships which matter.
Fraud by abuse of position, again, the offence, first of all, requires dishonesty and the intention to obtain a gain for oneself or another or cause another loss. Examples might be where an elderly person executed a power of attorney in favour of their son or daughter, and the son or daughter then effectively used those powers to obtain access to funds and to deprive that person of those funds. Another example would be if you placed money in the hands of a financial investor, you relied on him for advice, and he simply took the money and bought an expensive house on the Mediterranean and bought himself a yacht. That is the sort of situation where the section is meant to bite.
Section 4 could cover a variety of situations, and difficulties could be encountered in practice when determining what professional and fiduciary relationships are covered. What's clear, though, is that both acts and omissions are within the Act's scope.
Under Section 4 of the Act, you don't need any positive act. It makes it plain in the Act that it can be by omission as well as by commission. An example of an omission would be, for instance, if a stockbroker failed to tell his client of a particular move in the market that he knew was likely to come. Or indeed, if a solicitor, who's in a fiduciary relationship with his client, failed to tell him of some option whereby they might be able to settle the case, with a solicitor having in mind the gaining of greater fees.
The three offences carry with them one common feature: an intention to gain or cause loss to another.
Under Section 1 Fraud Act offences, it will always be necessary to show an intention to gain, either for the person who is making the representation, abusing his position, whatever it may be, or for another, or alternatively to cause loss to another, or to put that other person in a situation where there's a risk that he might well indeed lose as a result.
The common denominator for all three offences is first of all dishonesty, and secondly an intention to gain for oneself or another, or to cause another loss, or to expose another to the risk of loss.
The Fraud Act 2006 gives statutory teeth to a Section 1 fraud offence by introducing rigorous sentencing.
Under the Section 1 offences, that's to say the three fraud offences, it's a maximum of 10 years imprisonment and a fine, or both. It's also, of course, triable summarily, in which case the maximum is 12 months imprisonment or the statutory maximum fine, or both.
Under the Act, we now have hefty new offences of dishonestly obtaining services and making, possessing and supplying articles for use in fraud, such as skimming machines in these cash points. Now, the emphasis here is still on dishonesty, and it's clear that the impact of the Act will really be felt in those areas where automated methods of transacting have changed from the conventional methods of face-to-face dealing.
Section 11 of the Fraud Act provides that a person commits an offence if he obtains services either for himself or for the benefit of another by some dishonest act.
Under Section 11, it's necessary, first of all, for there to be a provision of services which are expected to be paid for, in the sense that either they have already been paid for, or that they are in the process of being paid for, or expected to be paid for in the future. It's then necessary for those services to be obtained when payment has either not been made or only been made in part. In that situation, if a person, a defendant, then obtains those services, he does so by a dishonest act, and he does so knowing at the time that those services should be paid for in the way that I've just explained. And he does so either intending to pay nothing or not to pay fully for those services, then he can be convicted of an offence under Section 11.
The old 1978 offence of obtaining services by deception has really been replaced in two ways in the new Act. In the first place, because the Section 2 branch of the fraud offence is so wide, it would cover, for instance, someone using a fake credit card to buy services. In the second place, Section 11 of the Act creates a specific offence of obtaining services dishonestly. This is a bit like theft of services, because there's no need for any deception to be proved. So it would cover that sort of conduct, obtaining services by deception, but it would also be wider and cover things like someone jumping over the turnstile in order to watch a game of football.
An example of it obtaining under Section 11 would quite simply be going to a restaurant and ordering a meal when you knew full well you weren't going to pay for it. There's a danger, on the other hand, if you decide only after you've eaten the meal that you're not going to pay for it, then Section 11 will not be the correct section to charge you. You'll need to be charged under Section 3 of the Theft Act of 1978, which has not been repealed.
The elements which need to be proven for an offence under Section 11 of the Act are, first of all, dishonesty. Secondly, it has to be done on the basis that the services have to be provided on the basis that they will be paid for, or they have been paid for, or that their payment is expected in respect of them. And thirdly, the services have to be obtained as a result of the conduct.
Again, the gravity of the offence is supported by the maximum sentence for a guilty verdict.
On conviction on indictment for an offence under Section 11, the maximum penalty is 5 years, or a fine, or both. If there's a conviction on a summary trial, the maximum penalty is 12 months imprisonment, or a fine of the statutory maximum, or both.
The Act extends in Section 6 to possession and supply offences and fills a number of gaps in practice.
The police were very concerned about circumstances in which they found things like skimming devices or fascia to put on the front of cash points at people's home addresses, because under the old law they couldn't find an offence which they could charge. Section 25 of the Theft Act had an offence of going equipped for theft or indeed cheat, but the difficulty with that was it specifically said whilst not at your place of abode. So when found at someone's home address, it couldn't be charged. The new Act does away with that by simply criminalising possession of articles for use in fraud.
Section 6 makes it an offence to have in your possession or under your control an article, and that could include a program for the computer for use in the course of or in connection with fraud.
Section 6 is a new offence which can be looked at in the same context of the old going equipped offence under the Theft Act of 1968, under Section 25 of that Act. The new offence is a wider offence in that it relates to the possession of any article at any place or at any time which might be used in connection with any fraud. By contrast, Section 25 of the Theft Act of 1968 only dealt with articles in the possession of a defendant whilst not at his or her place of abode and used only in connection with burglary, theft or cheat. So the new offence is a much wider offence.
Section 25 of the Theft Act 1968 penalises going equipped for theft and indeed includes cheat. Cheat has now been abolished so far as it's a provision of the Theft Act and is now covered by Section 6 of the Fraud Act. The penalty, in fact, is increased to one of 5 years imprisonment, whereas under the Theft Act, the penalty is only 3 years.
It's not just the fraudsters carrying out the dishonest act, for example credit card skimming, who are affected by the new Act. It's also their backup team who make the devices and supply them.
Section 7 of the Act creates an offence of making or supplying articles for use in fraud. The offence isn't a strict liability one. It's clear on the face of the Act that the person making or supplying the articles must intend that they be used in the course of a fraud.
The Fraud Act 2006 under Section 7 introduces a new offence of supplying articles for the use in connection with fraud or intending to supply them or adapting or making articles for use in connection with fraud. And the legislators regarded this as a more serious offence than simple possession of those articles.
The gravity of the offence is demonstrated by the penalties imposed by the Act. Under Section 6, for simple possession, there is now a maximum imprisonment in the Crown Court of 5 years and in the Magistrates' Court of 12 months. An offence under Section 7 carries a maximum of 10 years imprisonment and a fine. Sole traders have always been outside the scope of the fraudulent trading provisions of the Companies Act. Now, the Fraud Act 2006 extends these provisions to sole traders and also to other entities who used to be outside their scope. Section 9 of the Fraud Act 2006 states that a person will be guilty of an offence if he knowingly carries on a business to which the Act applies with the intent to defraud creditors or for any other fraudulent purpose. The Act's definition of person extends to any person who is outside the scope of Section 458 of the Companies Act. Section 9 of the Fraud Act 2006 also changes the sentencing structure under the Companies Act for a guilty verdict, so that penalties under both acts are the same.
Section 458 actually provides a penalty for fraudulent trading, but is confined to fraudulent trading by companies. The new Act is designed to extend that to sole traders and trustees and people of that sort. So it's not confined simply to companies.
A Section 9 offence effectively requires an element of dishonesty. Dishonesty is not specifically referred to in the provision. However, dishonesty was always a requirement effectively in relation to the 458 offence under the Companies Act.
Well, the main ingredients are dishonesty and running a business fraudulently. It's not confined simply to creditors, but any general running of a business fraudulently.
Under the new law, we now have the ability to prosecute individuals for fraudulent trading when previously that was not possible. individuals, whether they're acting as sole traders in business, whether they're acting as partnerships in business, or whether trustees acting together in some kind of trading activity. All of those classes of individuals can be prosecuted under the new law.
Sentence structures have changed so that they now mirror evolution in fraudulent trading.
Under Section 9 of the new Act, the maximum penalty which can be imposed is 10 years imprisonment for an offence that's tried in the Crown Court. It is an offence which is triable either way, that is either at the Magistrates' Court or at the Crown Court, but the maximum is 10 years in the Crown Court. In addition, Section 458 of the Companies Act has also been amended by the Fraud Act in that the penalty for that offence has been increased from 7 years to a maximum of 10 years, so that there is complete consistency in relation to fraudulent trading, whether it's committed through an individual's actions or through corporate activity. And that also is consistent with what Parliament has imposed by Section 1 of the Act, because there is a maximum of 10 years imprisonment.
The Act has met with favour amongst practitioners, but there is still debate about how far the law has evolved and to what extent the future requires braver intervention in order to keep one step ahead of technological advances.
It's impossible to say how fraud is going to develop in the future and how law relating to fraud is going to develop in the future. What is certain is that as technological advances have occurred over the years, then fraudsters have found a way to harness those advances for their own benefits. Very often the law has lagged behind those advances, and we're now seeing this Act being brought into force to deal with some of those mischiefs that have occurred as a result of some of those advances. I don't know what's going to happen in the future, but there will be a need for further reform in due course as technology advances.
The Fraud Act is an indication that the government are concerned to ensure that people can identify what is meant by an offence of fraud. It's clearly not comprehensive at the moment. There are a number of other offences which can be considered to be fraud and which could, if the government thought appropriate, be included in an act of this nature. It may be assumed that in future, as time goes on, and if this Act is successful, that the government will intend to increase those offences which can be labelled properly fraud. Whether they do that by amending this Act or passing a completely new Act remains to be seen.
To a degree, then, the Fraud Act 2006 has met its aim, eliminating anachronistic concepts and setting a firm base from which to capture dishonest activity which operates in our online automated world. Some argue, though, with good reason, that the Act needs to evolve further to solve those anomalies in practice, not least in relation to conspiracy laws. That said, it is a move in the right direction, and certainly its clarity will be welcomed by the business world.